Accurate, dependable, and late-breaking. This is local and state news on WLEN, Lenawee's local news station.
The Lenawee County Court's modified bond conditions today for a former investigator, Kevin Greca, now listed as a material witness in the Dee Warner homicide case. The hearing focused on whether existing bond terms were appropriate and whether the process used to bring Greca before the court was punitive. Defense attorneys told the court they were not present for the December 12th hearing, but confirmed their client has now retained counsel, paid the $50,000 surety bond, and has been released. Defense said they are challenging the scope of the hearing, arguing it should not be limited to bond conditions, and signaled future motions related to how the earlier proceedings were handled. The judge clarified that only bond imposed by the court was a $50,000 cash or surety bond.
Your Honor, although I'm not entirely privy to what happened on December 12th as it relates to the hearing that was conducted, I do understand that my client did not make a statement regarding, he did address bond in the court, ended up setting a $50,000 surety bond. That surety bond has been paid and he is ultimately released. What we take issue with today, if we are limited at our scope to a bond hearing today, which is what this was noticed as, is the bond conditions. And I would like to take some testimony today regarding that. I do take issue with how things were previously conducted, but we're not here to address those today, and I will file any appropriate motion that I will need to in order for you to consider that once I've reviewed the transcript.
That's fine. I do not have any bond conditions.
Yes, you do, Your Honor.
No, I do not. It was a $50,000 surety.
Judge Olsaver stated that no additional bond conditions had been imposed beyond the bond amount itself. Defense then requested a court order removing a restriction placed by the bonding agency that prevented the witness from leaving the state of Michigan.
Okay, just for clarity's sake, there are no conditions on his bond that have been imposed by me other than the $50,000 cash or surety.
So then I would ask for an order stating that the bond condition of the bonding agency that states he is not allowed to leave the state of Michigan be removed.
Prosecutors acknowledged the witness has now appeared with counsel and said that weighs in his favor. However, prosecutors argued that authorities had difficulty locating him for months and said his time in Ohio was more than a routine dinner trip. The prosecution said travel restrictions were imposed by the bonding agency, not the court, and left the issue to the judge's discretion. Prosecutors requested limited conditions requiring the witness to notify the court of any change in address or phone number.
Your Honor, the fact that he's hired an attorney and he has appeared today does go a long way, but it doesn't change the fact that we had to look for him for 8 months and he was in Ohio for a period of time. It wasn't just to go out to dinner. However, this court hasn't set that as a bond condition that he cannot leave the state of Michigan. That's understood. That's part of the bonding agency. I would leave it up to your discretion. I would, however, ask the court to make a bond condition that he does notify the court if he does change his address, if he does change his phone number. Those are the conditions I would be asking for, Your Honor.
Judge Michael Olsaver stated that the court has never labeled the witness a fugitive and emphasized the court acted under Michigan's material witness statute. The judge said the purpose of the order was solely to determine whether bond was appropriate. Citing the posted bond, the witness's legal representation, and the proximity to the Ohio border, the judge ruled that the restriction preventing travel outside Michigan would be removed.
All right. I would first say, since the topic has come up, the court has never at any point tried to or even intimated that retired Detective Greca was a fugitive from justice or anything of the like. The court issued an order pursuant to MCL 767.35 for a material witness to be brought before the court for the purpose of having a hearing to determine whether a bond was appropriate. I do think, given the fact that retired Detective Greca has obtained counsel and has posted a bond with the surety in the amount required by the court, that eliminating the forum provision that he not leave the state of Michigan is appropriate. I'm obviously aware that we live very close to the Ohio border, and it's common for IPA to cross back and forth. And I'm comfortable in this case with retired Detective Greca doing that, given the bond and what was in place during. So I would make that modification.
Defense attorneys argued the surety bond has had a punitive effect, noting that bail bond payments are non-refundable and that the witness was held in custody rather than being brought directly before the court. They argued that the statute allows a witness to acknowledge a subpoena without detention and said that process was bypassed. Defense indicated they intend to challenge the bond structure and earlier proceedings in future filings.
I do feel that the surety bond at this point essentially has become punitive. He paid the 10% through a bail bondsman, and as is required in the surety bond, once a person pays a bail bondsman, they are not getting that money back. So essentially, this court's order did have the force and effect of being extremely punitive to him in exchange for the fact that he was also held in custody for multiple hours as opposed to just being brought forth to the court, as your order of attachment did suggest, in pursuant to the statute. He did not, we kind of bypassed the fact that he would be able to come and make witness for himself, as is required in your order of attachment under MCL 67.35, that he would have an opportunity to recognize for himself, yes, there is a subpoena out there for me. Yes, I accept that. Instead, we immediately went to bond, a surety bond that he is going to have to put, either still stay in jail today, which is well beyond the 72 hours that we would be looking at. And this order was also put in place 4 months or more before he is due to be in trial. So at this point, I think that things that have been done, and I will expound on them in further hearings, have an extreme punitive aspect to that. And so that is why I was asking you to consider that on the comments of counsel.
Judge Olsaver said the material witness statute authorizes a surety bond and does not allow for a 10% bond option. The judge said that is why the court imposed the bond as structured and declined to convert it to a personal recognizance bond at this time. The court left open the option for further motions or briefing on the issue.
I would point to the statute, MCL 767.35, as the court's basis for requiring a surety bond. That statute says nothing about a 10% bond, and so I did think about a 10% bond when making my decision on going forward. And in reading the statute, did not believe that that would be authorized by the statute, and so there's a reason that I did not do that. I've stated my reasons for maintaining the surety bond, which I'll do at this point. And if you'd like to have a further hearing on that or brief it in any way, you're welcome to do so.
The surety bond remains in place, and travel restrictions imposed by the bonding agency were lifted by court order. Additional hearings and motions are expected as the case moves closer to trial. I'm Brian Vish for WLEN, Lenawee's local news station.
Count on WLEN, Lenawee's local news station, to keep you informed with accurate and dependable information 24 hours a day.